All right, be seated. My understanding is you all have reached a verdict. Is that right?
Yes.
If you would hand the verdict form to the bailiff for me. Thank you. All right, the verdict form is in order. If you would publish the verdict and poll the jury, please.
Yes, ma'am. State of Florida versus Jermaine Bass. Case number 22 CF 011717A. Trial Division 3 verdict form. We the jury find as follows as to count 1, murder in the first degree. The defendant is guilty of murder in the first degree, Jayla Bass, as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause death of the victim? Yes. 12 of the 12 of us find the killing was premeditated murder. 12 of the 12 of us find the killing was premeditated murder and felony murder. We the jury find as follows as to count 2, aggravated child abuse. The defendant is guilty of aggravated child abuse as charged. We the jury find as follows as to count 3, aggravated child abuse. Jermaine J.J. Bass. The defendant is guilty of aggravated child abuse as charged. We the jury find as follows as to count 4, attempted murder in the first degree. Jermaine J.J. Bass. The defendant is guilty of attempted murder in the first degree. Jermaine J.J. Bass as charged. And during the commission of the offense, did the defendant personally carry, display, use, threaten, or attempt to use any weapon or firearm? Yes. Did the defendant actually possess a firearm? Yes. Did the defendant discharge the firearm? Yes. Did the discharge cause great bodily harm to the victim? Yes. So say we all, dated this 27th day of February 2025, juror number 1, foreperson of the jury. Juror number 1, are these your true and correct verdicts?
They are.
Juror number 2, are these your true and correct verdicts?
They are.
Juror number 3, are these your true and correct verdicts? Juror number 4, are these your true and correct verdicts?
They are.
Juror number 5, are these your true and correct verdicts?
They are.
Juror number 6, are these your true and correct verdicts?
They are.
Juror number 8, are these your true and correct verdicts?
They are.
Juror number 9, are these your true and correct verdicts?
They are.
Juror number 10, are these your true and correct verdicts?
They are.
Juror number 12, are these your true and correct verdicts?
They are.
Juror number 14, are these your true and correct verdicts?
Yes.
Thank you. I can't see.
You missed
I
one.
can't.
I was 12. You missed
You missed 11.
11, excuse me. Juror number 11, are these your true and correct verdicts?
one. Yes, they are.
Thank you.
And juror number 12, are these your true and correct verdicts?
I can't see.
Yes?
Yes.
Okay, thank you.
Okay, thank you.
All right, ladies and gentlemen, I know that you have spent a considerable amount of time and effort today deliberating on this case, and I cannot thank you enough for that, as well as your patience and with us and hard work all week. As you've now seen, it is why we need people like you who respond down with a jury service summons to handle the cases and the disputes that the parties cannot resolve among themselves. So you are essential and a true backbone to our system of justice, and I cannot tell you how much you are appreciated by me personally, as well as all of the judges here in Tampa, Hillsborough County. That much being said, all of my constant admonitions about not talking about the case are obviously lifted. You can do as much speaking about the case as you would like to, or discussion or investigation or whatever you'd like to know in addition to what you've heard during the course of this trial. I do hope if you share your trial experience with others, it does have a somewhat positive spin so that when they get a jury service summons, they too will come down to the courthouse, as you all have this week, to serve the citizens of Hillsborough as you all have. I spent a considerable amount of time as a trial lawyer before I became a judge. I loved to talk to jurors after cases to see how the presentation went and what questions jurors had or didn't have, or just talk about deliberations in general. That option is open to you. Of course, you're not required to do that, but if you wanted to talk to any of the lawyers, or if you have any feedback for me, let the bailiffs know and they'll tell you not only you have my contact information, you're welcome to get back in contact with me, or if you want to come back in and speak to any of the lawyers about their cases, you're welcome to do that as well. But officially, your jury service is concluded with the thanks of both parties and with the thanks of all of my colleagues, the judges here in Tampa, Florida. So thank you very much for your service. Maybe we will see you down here next time you get a jury service summons, but thank you for all of your efforts this week. Have a great rest of your week and weekend. All rise. All right, have a seat. Any reason not to proceed with sentencing at this time?
Well, Judge, yes, we'll be filing motions, and also there would need to be a score sheet for the other counts, so I would request sentencing be set off.
All right,
And I also need to discuss then very briefly as well with Mr. Bass about a PSI.
all right, sure.
That's fine, Judge. I had not prepared a score sheet. Obviously, I didn't know what the verdict would be or what if it could be lesser, so I just didn't have anything prepared. But and I know, Judge, in speaking with the family, I believe at least one of them would like to say something. So I know if we can just maybe have another date.
All right.
About that.
Of caution in case this affects either side's sentencing request. This will be my last jury trial. I am retiring effective in a couple of weeks for another opportunity that I have to go into private practice that I'm going to take up. So I won't be the sentencing judge if you want to defer it. But I know that any replacement would be reading the trial transcript as well as familiarizing himself with the testimony that's being conducted. So if that weighs into your decision making about whether or not you want to proceed today, just take that into consideration in telling me what your preference is.
Can we do it before you leave, Judge? Or before your last day on the bench?
We do, yes, and we're waiving PSI, Judge. I have discussed that with Mr. Bass.
All right.
I could have the score sheet ready by next week for sure. Even potentially by tomorrow if need be.
I'm not-
Oh, you're not here tomorrow. Okay.
You're what? Can't do it tomorrow?
But I definitely by next week I can have if you have a date next week, I can go ahead and have a score sheet ready and we can proceed with sentencing.
Can you do it on Monday?
I do have open time next week, but I would need time to do motions. Wednesday? What do you have on maybe Wednesday?
Well, if we had proceeded to sentencing anyway, you can always file the motions after that.
That's true. That's true.
Good.
Monday's fine with the state.
The only problem is I think we definitely want you to be able to hear both, just because you heard the trial. And any post-trial motions that we file are gonna be more complicated if someone's then gonna have to get the trial transcript and review it, you know what I mean?
Do you have time Wednesday? Or Thursday afternoon? I know we have the morning in here with you, or Friday. Is that possible?
Approach the bench for a minute.
Court's
All right,
adjourned.
all right.
Go to courtroom, please.
Have them waiting.
Yeah. All right, everybody. So the jury found him guilty, and they adopted obviously the theories, or they adopted the expert testimony, and they're But to me, it shows there's definitely questions. That's why this wasn't a quick verdict. There were people back there that had problems with this case, but ultimately, as I said, if there was only a few, then they would move to a verdict one way or the other. And clearly, there were more people back there who adopted what our friend Columbus says. And I'm not saying, as I told you, there wasn't a path here. The jury gets to determine what's fact, and there was ways. If they decide that expert testimony on the trajectory says only he could have done it, then they can adopt that. I mean, and they can say that is fact. They are the true triers of fact and truth. They get to determine it. But in my opinion, if I was sitting back there, there's too much doubt, in my opinion, as to explanations that could explain that you could not reasonably rule out what happened here. And the state did not bring enough evidence, in my opinion, to go beyond a reasonable doubt. But that doesn't mean I don't think he couldn't have done this. And listen, I respect the jury's verdict anytime the jury returns one. And now they're going through the appellate process, and we'll see what happens. If additional evidence at some point comes to light, I think they're going to go through with sentencing today. I just have this lingering suspicion that that's why the judge called him the sidebar. They're going to go talk to the family outside, and they're going to try to let the hearing go today. And I think the judge is trying to convince them, let's do the sentencing today. You guys can file your motions. I'll hear the motions, make a ruling on the motions, and then we can get this all taken care of and worked out today. I think she's trying to get the sentencing and everything out of the way and off her docket, so that all she would have then are motions that would be briefed, and possibly, I don't even know if they could brief them, and then she could call them in for arguments if she wanted to, if there was a need. The judge will turn it down. I don't think she's going to rule against, say that she made any mistakes. All of this is just standard, but these are things that need to be done. These are things that set up the appellate process. These are things that will allow these lawyers to get out of the case, because the lawyers that try the case are not going to be the ones that are going to be appealing the case. They have a whole set of attorneys that will be available to be appointed, partly because, again, as an attorney, you have to look at your own actions, your own decisions. So you want to bring a third party in and let them evaluate. That's part of what making the appeal process. That's what makes the appeal process work. So I'm sure they all want to get rid of this. They all want to get this off their case and off their desk, and move on to the next case. So I think that's what they're working on right now. And I think we'll be back and have a sentencing here shortly, but could be wrong on that. But I think we will. But do I disagree with the verdict? I mean, I do, from the standpoint of, I had doubts. I would not be comfortably sitting back there going, I'm comfortable voting guilty and saying beyond a reasonable doubt. Do I have a problem that those 12 people did? No, I don't, because I do believe, there's a way to get there, I guess, if they want to adopt and say that the only person that could have fired these shots in that household was him, based on the trajectory of the bullets. And they say, he was the only one there, and it was either the kid or him, and they adopt that there's no way that child could have fired it. And I don't know what evidence they're relying on to say she wasn't in the house, because there's been no definitive evidence to say so. But if you adopt and accept part of what he said, which is that the gun was in his hand, and then you say that the only person that could have fired that is someone who's 5'5" or higher, there you go. And they're comfortable with that's proof beyond a reasonable doubt. You know what? But I don't believe everybody was in that jury room. But I think there were some people that said, I don't want to be responsible for sitting back here for the next, 6 hours to get to a hung jury. And they were convinced. That's what happens. Like I said, I remember when I was on the jury, it was 10-2 guilty when we had our first vote of the highest charge. And that's not what we walked out with. But, I'm glad to see that they did take time. No one's going to say they didn't take appropriate time. They definitely took a lot of time on this case and debated it. And listen, Columbus, I appreciate you coming in. I like to have spirited debates. I like to hear the other side. I don't like to just talk to people that agree with. I think it's fun to have that other side. It challenges me and challenges me. And I'm going to go back and look at things. So, I'm fully aware of that, but I'm saying that can still be a doubt in the jury's mind that says this doesn't make any sense. Like, motive is important to jurors lots of times, right? I mean, a lot of jurors that can. Now, again, that's fair pointing out. You don't have to. That's why I said you don't have to. All you got to do is prove that, again, this jury adopted the idea, and again, they're allowed to do this, that part of his statement was false, the other part was true. And the part that was true was they adopted that he admitted to having the gun in his hand. And that's what the state was asking him to do. And then after that, you apply the expert witnesses that says, as you said, if they believe that expert for them took away any doubt that the 5-year or the 8-year-old could have done this, there's only one adult then in this picture that has the gun in their hand based on his statement. It's him. And by that, we now get to that says, okay, he intentionally fired these shots at his children. He failed to kill the kid, and everything else doesn't really matter. Everything else is just, it doesn't line up perfectly because I don't think anything ever does. But for me, when I'm looking at this case, I'm saying, okay, hold it. That statement. All right. Why is he lying? And I'm going to say we need to prove why. Why did he lie about the magazine thing? And at that point, the way I see it is, it's not a credible statement to even say the gun was in his hand because the way he said the gun was in his hand doesn't make any sense. So, um, so that answers that. You guys probably heard that it looks like the court ended, um, and we're not going to be getting a sentencing hearing today. So it looks like no sentencing hearing today. I was wrong on that, but I thought they might try to push it. I thought that's why they were taking him out to the hallway. So here it is, guys. It looks like we're getting a sentencing hearing. We don't know when. They were trying to push for Monday. We don't know if it'll be Monday or Wednesday. It'll be sometime next week. I'm sure we'll find out here soon. I'll check the docket down there. The nice part about Florida is you can find everything out online. So as soon as it goes up, it'll be there. As soon as those motions get filed, it'll be there, and I'll be able to take a look at those and see what I think about them. We will be talking about this case on my international podcast on Saturday. Again, you already have heard a lot of what my thoughts are. You're going to get to hear my co-host. If my co-host disagrees with me, and she very well might, then it'll be a nice spirited debate between her and I. And of course, all of you, Columbus, everyone, I invite you in, come in, let's debate, let's have some more talk. And I'm going to do a little watching back. I'm going to do a little reflection myself and see, if maybe I need to just, reevaluate a few things that I saw, look at things a little closer. And the thing is, I think that's really unique about the way these jurors, when you're on a jury, that you have to rely on your own. There's an exception to hearsay. It's called present sense impression, right? It's the same thing in a jury. It's your you have to rely on that. What's your present sense impression of the witness, of the evidence, of everything that's happening? And you get to take that with you back to the jury room. And that's why some judges really go the extra mile to try to ensure that a jury is adhering to that they're getting only their most just the best first impression they can of the evidence, and that they take that with them, that they don't even let them take notes or nothing, because I agree with it. I understand it. When you start to take a position, like when I start to take a position, and this is why I'll go back and I'll reevaluate. When I start to take a position, I dig in, I find the evidence that supports me, just like anybody that takes a position against it. If you do that too early, you miss things. Perhaps I've done that. And whenever I look at a case and I'm looking at a position in a case and it doesn't go that direction, and I know there's 12 other people and there's Columbus and there's 75, 80, 90% of my chat out there that have a different perspective, that challenges me to go back and say, okay, did I get tunnel vision? Did I dig in too soon? Did I start making assumptions? Did I hear something? Did I rewatch too much? because if I would have been a juror who didn't have access to rewatching the case and rewatching testimony and breaking things down and relooking and looking left and looking right and looking at all angles, if I just heard this for the first time and I walked away from it, what was my real sense? Did I dig in too soon? Did I hear something and said, oh my gosh, you know what? It makes sense. That could be that. And then I just started to say, you know what? I'm doubting everything. And then, in that mindset, I missed. And that's what you don't want to do as a juror. That's what you hope, that when jurors are sitting there, that they're truly not making any impression whatsoever on they're not making any determination on the case. They're just hearing the evidence. It's difficult to do, but that you're hearing the evidence. And then when you get back there, that's when you start to deliberate. That's when you start to think out loud, talk about it, start to decide where you're at with this case. And sometimes it takes an hour, sometimes it takes 30 minutes, sometimes it takes 10 hours, sometimes it takes 3 days, sometimes it takes 6 hours and however many minutes this jury deliberated. So hats off to the jury. It's a difficult job. Nobody wants to have somebody's life in their hands. These people did, and we respect the verdict, always do, and respect everybody's opinion. So appreciate everybody that participated in this trial, and there are other trials going on right now. With the Rodriguez case, something happened, I don't know, with the feed. I think something got shown and the feed got yanked. I don't know if it'll come back or not. This happens, especially when you have a judge that doesn't want things, and then a cameraman gets careless. We saw that in the Boswell case. That cameraman went to jail for 10 days. So these cameramen, they got to be more careful. They can't be showing things they're not supposed to. We have the Simontilli case. That'll be going to probably 7 o'clock tonight, Eastern Standard Time, 7 to 8 o'clock. We've got the Todd Mullis case. It's over there. Now, it's not a traditional trial. It's more of it's an appeal, right? So it's where a case like what we just watched could go to someday. This is where this man is seeking post-trial relief, and he's doing so through the civil courts, where he's having a full civil trial, bench trial, to where this judge will hear all what's alleged to be new evidence and make a determination. So Jamie says, I just watched Jayla's funeral. Too many pictures of her with Jermaine. Yeah, well, I still feel like there's something wrong with this. I just feel that way. There's something wrong with this case. There is, and it really bothers me. And it bothers me that mom didn't show up. There's something that happened here, but didn't matter. Doesn't matter. I mean, it does matter in relationship to an appeal, and it will matter. Hopefully, if there is more to this thing, hopefully it'll get found out one day. If there is someone that knows more, maybe they speak up. We'll see what happens. The idea that if he didn't do this, if this isn't what happened, maybe somebody decides to push across the line and come across and say, this is what really actually happened. This man can't go to jail for the rest of his life. But we'll find out. It's a devastating, tragic case. It really is. And let me tell you something. I would not want to be that man going to a Florida penitentiary system with the blood of a little girl on your hands and the blood of your son, an 8 and a 5-year-old. Like, one thing that goes understated is, the state has an obligation to get you to trial. So the fact that somebody makes it to trial and is unscathed, it means nothing about what's going to happen in the future to them when they get into the prison system, because the state has an obligation to keep you in protective custody, to keep you safe, to keep you to where, because you're presumed innocent. So they have to, right? They're holding you because they're concerned you might not show up, or maybe you're a danger to the community, but you're not being penalized. You're just being held so you can come answer the charges, and they're trying to maintain your presumption of innocence while at the same time maintaining security and making sure that you're there. But after you get convicted, after you're sentenced, they're not going to care anymore. And man, oh man, this guy, would not want to be him right now. But you know what? If he did what he did, You know, that's why it is what it is. You know, best thing to do is if you're going to be a firearm owner, be responsible. Keep your firearms where they're supposed to be. Lock them up. And certainly don't kill your kids. Don't kill your significant others. Don't solve things through violence. I mean, it's just life 101, right? And if you do, the rest of your life's going to suck. It's not going to be fun. And it ain't going to be fun for him. Anyways, with that said, guys, I appreciate all of you. Hopefully I'll see you guys on Saturday if you want to come in and talk. And check out the International Podcast where we're talking about this case. And we'll be talking about other ones too. This is going to be we're going to talk about this case, and then I'm sure we will delve into the other cases that are out there, the other cases that have been happening. There's so much going on, so much to talk about. Anyways, with that said, I'll talk to you guys soon. Let justice prevail, and I'm going to send you guys over to the Seaman Tilly case, the 5 of you that remain. So if you hang on, you get over to that case. They're still on lunch break, but they should be coming off anytime soon. They're on their California lunchtime, man. Let me tell you, they take an hour and a half to almost 2-hour lunches, take 45-minute comfort breaks, and they get about 3.5 hours of testimony in a day. So who could argue with that schedule? I mean, it's unbelievable, but it's what it is. It's why California takes 9 months to 10 months to 12 months to get a case done. But anyways, with that said, guys, send you on over. Head over to the outro, and I'll talk to you guys soon.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.